welcome all of you, those who are present before me and those who are online. I presume the judges who are here belong to Gangtok. Local? No.
All districts.
Other districts also. And if you see the topic, with latest judgments, so digressing from my written topics, which I have been always accused of, sir, आप जो लिख के लाते हो हमको पढ़ाते नहीं हो. And therefore, the director asked me, should I give away the papers right away? I said, any time you give it, they'll not find much semblance in what I am telling them. Because the beginning which I am beginning, say the latest judgment, this I could download. This is a November 2022 judgment of Sikkim High Court. Maybe it does not speak much on the sentencing policy, but it speaks about minimum sentence. So where I'll take you to this judgment, and I think it has been circulated also. Criminal Appeal number 11 of 2021. Suman Guran versus State of Sikkim. The main challenge was to the length of the incarceration meted out. Length of incarceration. Do you want me to even tell you something in Hindi also? Or English is fine for all of you? Because I don't use those high profile words when I'm at the academies. I don't even use high profile words even in my judgments. The reason I'll tell you why. And I even tell my judges not to use those words which you will find only in the Oxford Dictionary of difficult words. Why? See, as a High Court judge or as a Supreme Court judge, who reads my judgment? Who reads my judgment? This is my philosophy. I may be wrong. Who reads my judgment? Either a district judge, either a judicial magistrate who deals with quasi-judicial matters, or my other judges. So they don't want me to write the lackadaisical approach of the government is deprecated. You'll find, छोड़ आगे बढ़ो क्या लिखा है देखा जाएगा. You don't want to sit with a dictionary with you when you are reading a judgment. So let your judgments be as simple as they are. There's a difference between being cryptic and being simple. See, earlier judgments were short. They were not verbose. Why? Why? This is just digressing so that 3 hours you may not feel के yes board us इसको कह दो district judge, chief justice को कि इसको दोबारा सिक्किम नहीं बुलाने का. I don't want that for me. So I normally, even this is a very dry subject, sentencing policy, a very dry subject. And you feel उसमें क्या पढ़ने का है? Why has the chief given 3 hours to this topic? But let me tell you, recently, the Patna High Court, all those who are subscribing to live law, Patna High Court had to tell the judicial directors of the academy that please have a curriculum on sentencing policy. Why? Yesterday I have told in my judgment, as he told, no, I have left many things. The last judgment which I penned with my brother colleague, who is a new judge, I told him, इतना लंबा लंबा काहे लिखते हो? He was very correct. सर मैं नया हूँ, मेरा confirmation अभी बाकी है. So okay, fine. So you take this judgment on This is a very nice judgment. It's not a very lengthy judgment. The limited challenge in this appeal is to the length of incarceration meted out to the appellant by the learned trial judge. Maybe some of you might have penned that judgment, I don't know. See, this would come in the second topic. Policies. This is based on the policies. And it takes into account many judgments, then comes to the minimum sentence. In light of the provisions of law, the principles of law enunciated, extracted above, and duly perused and considered the sentences imposed by the learned trial judge, it is evident that only the minimum imprisonment prescribed by the statute has been meted out by the learned trial judge to the appellant. Why? Now why did the bench did not interfere? Why? Can somebody tell me why? Should I read it again for you so that things are very clear? In light of the provisions of law, the principles of law enunciated and extracted above, and having duly perused and considered the sentences imposed by the learned trial court, it is evident that only the minimum imprisonment prescribed by the statute has been meted out by the learned trial court. Why did they not interfere? Why? Don't feel shy, this will not come in your ACRs. The director will not write anything. See, every judge has his own perception. And therefore we don't have any straitjacket formulas.
Minimum sentence.
Yes. See, you cannot give sentence which is even minimum than the minimum prescribed. So that is a theory. Because my Lord said that I should go with latest judgment. This is one of the latest judgments. Second, I will take you to the judgment of Allahabad High Court, dated second of March, that is yesterday, day before yesterday. Penned by my brother Justice Azhar Hussain Idrisi in Criminal Appeal number 630 of 2014, dated 2/3/2023. There the issue was, the man was convicted under section 302 of the Indian Penal Code. His defense was that he and the other accused who had absconded, they had gone to a park. This was his defense in 313, which was not believed by the learned trial judge. And at that time, the victim and his other friends were harassing some girls, and a commotion took place. In the heat of the moment, this accused also inflicted certain blows. The learned judge said, no, we are not ready to believe, I am not ready to believe that it was in heat of passion, and 302 sentenced for life imprisonment. Because under 302 you have no other option but to either go for 302, and he gave about 12 pages on everything on sentencing, why I am not giving death sentence. Don't waste your time. Why? Why I am telling you? See, now, earlier it was a theory that death sentence should be given and life should be the other way around. Now the law after the independence has changed. It is life, and only in rarest of rare cases it would be death sentence. Now, can you say this was rarest of rare case? Even on these bare facts of 2 sentences which I gave you on these facts, why waste 12 pages with all these pendences lurking around your head? Why? What for? And at the end of the day, what happened is, the man has been incarcerated for 15 years. He's in jail. All that the learned advocate said, sir, either it's a case of acquittal pure, or at the most 304 part 1 or part 2. So after a lot of reasonings, my brother said that yes, it falls within 304 part 1. And then I concurred with it. And then he has even narrated all the theories. Of course, that is copy-paste from my earlier judgments, based on whether he should be sentenced to be in the prison for throughout his life. Because even 304 says imprisonment for life. I still don't understand this anomaly. Once you are saying maximum is 10 years, why do you have to add all life? What is the purpose? I have still not been able to fathom those objects and reasons from the Indian Penal Code. I just read for your benefit 304 part 1. If you have your books, you can take them. Otherwise, peacefully hear me. Punishment for culpable homicide not amounting to murder. Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life, or imprisonment of either description for a term which may extend to 10 years. Maximum you are giving is 10 years. Extend to 10 years. In the alternative, we are saying no. Life ke liye bhi rakho andar. What is the purpose? In my young days as a college-going student, I tried to go through the objects, reasons for this transportation of life. Because in your young days, you are told that IPC, Macaulay, this, that was a great piece of extend to 10 years, and shall also be liable to fine. If the act by which the death is caused is done, the intention, maybe. And then, 304 part 2, you give such a leewage. Or with imprisonment of either description for a term which may extend to 10 years, or with fine. Or with fine. Not and fine. And that is where, if you have read the judgment of the apex court in Ankush Gaikwad, which I have used umpteen number of times, मैं कह दूंगा वो Ankush Gaikwad, 2013 judgment, the well-penned judgment of Justice Thaker, which says that if the parties wishes to compromise, and if you are invoking 357, you are invoking 357, enhance the compensation, lower the punishment. But that has to be, for the trial court judges, should be rarest, otherwise you will be misunderstood. The moment, I'll tell you, in an acquittal appeal, I asked the counsel for the accused, just imagine, would you like to go for Ankush Gaikwad? Is this not a clear word that we as a bench are going to upturn your acquittal? When does Ankush Gaikwad come? When you are sending somebody to prison. He didn't take any objection. The informant's wife took objection. ये कोर्ट में हम पे भरोसा, आपको भरोसा नहीं है. I said, thank you. Bye-bye. Go to other court. 1 minute. One of my judges from Gujarat who is in some trouble. See what happened with trial judiciary. You must have read recently, they were all on live law. One of them. He was he had come to that station before 3 months. The poor fellow writes to the High Court, this matter is pending since 10 years. Please give me 6 months more to finish the matter. I'll finish it. The Honorable High Court judge asks his explanation. Why have you yet not finished? He said, sir, I have come before 3 months. Again a correspondence comes. What did you do in 3 months? Then ultimately the learned judge on the judicial side says, all this should be written in the dossier of this judge that he has not completed this matter. जज करेगा तो क्या करेगा? उसके पूर्वजों ने मैटर खत्म नहीं किया. ये कहता है मुझे 6 महीने दे दीजिए मैं खत्म कर दूंगा. You say नहीं, we will write in your dossier. And a very bright officer, he has worked with me as a trainee judge. He is now a district judge. With that 10% होता है ना आप लोगों का प्रमोशन वाला एग्जाम देके, he is one of them. Very bright, knocking the doors, poor fellow. Now coming to subject proper, I have told you these 2 latest judgments. It's okay. So you see, I and Director sir were there at Delhi. This is not my coinage. This is said by Justice Pathak from MP. Every file has a life. I put it, how do you say that? Why? What is that? When it is put across, you may feel it's absurd. Every file has a life. What do you understand by that? Every file has a life. Just turn the words. Life is L-I-F-E, file is F-I-L-E. You take a file in your hand. You're playing with somebody's career. If it's a civil suit, it's a criminal matter also. You're playing with somebody's life. So therefore, he has coined this very nicely. Every file has a life. I put it converse. Every life will culminate into a file once it comes before a court. You are there to decide. What do you decide for him? And as I have been telling, and there again you will find a difference. I don't these days call my judges judges. We are no longer judges. We are judicial officers. Can you tell me why? You will feel, sir, what is the big difference between the two? There is a huge difference. What is a judge? Who is a judge? Who is a judge? What is his basic function? Anybody, don't feel shy.
One who decides.
Decides, right? These days, do you only decide? Do you only decide? Do you only decide? Brother, do you only decide matters?
We try to also give justice to the parties.
That is again decide. It's a better way of telling, yes, I am judging. Why do I call you a judicial officer? He is not a judge. Right now, sitting here, I am not a judge.
Because apart from the judicial functions, we have various other
What are they?
administrative functions.
Forget administrative. That a judge also does. That's a part of a judge. What are your other functions which the statute has imposed upon us? Which in our earlier days, when I joined, it was minimal, now it is maximum. Tomorrow the member secretary will tell you, go hold legal literacy camp. Are you a judge there? Right? The member secretary and the district judge will tell you, there is a mandate from the executive chairman. You have not performed your duty as a person who sits on the Lok Adalat. You have miserably failed. तो भाई वो उसको सेटल नहीं करने मैं क्या उसको गोली पे रख के सेटल करवाऊं? So, apart from being a judge, we are made as judicial officers. Tomorrow the director will tell the district judge, come as a resource person. Is he a judge? Therefore, see, you may feel that what I tell at the beginning, say you are not judges. Why? See the etymology. The system has rendered us judicial officers. पहले का जज सैटरडे संडे कभी काम नहीं करता था. I have never seen my dad working on a Saturday Sunday. They would relax. I had to tell my Chief Justice when I was district judge कि सर फैमिली जैसा भी कुछ होता है. Saturday you keep a workshop, Sunday you keep a Lok Adalat, next Saturday Sunday you tell us to go for legal literacy camp. Please think. Then Gujarat boiled down to one Lok Adalat a month, one workshop once in 3 months. Fine. Then there is a theory known as broken window. In one of the novels I had read about broken window. What is that? Does anybody know it? Broken window theory. Well, I'll tell you later on. Now I'll come to my topic first. I've taken 20 minutes in making you at ease. And as far as that the PowerPoint presentation is concerned, we'll do at the end. The reason I'll tell you. अभी से कर देंगे तो इनको सब पता चल जाएगा. So we'll refresh it at the end. Otherwise it will waste over half an hour. And then this lecture which I have prepared of 80 pages will go waste. No, 80 pages because I have to blurt out 3 hours. Because the director thought that इसको वहाँ से यहाँ तक बुलाते तो और किसी को नहीं बुलाना. He'll go them enough. Any other lecture after one? No. They'll be free. Good. Say, I have taken this topic as given to me by the Honorable Director, but I have bifurcated it into certain points. You can give away the notes if you want.
We have it.
No. My notes have been given?
Yes.
Okay. There were certain, you see, this was prepared hurriedly, so there were certain gaps, certain judgments, their citations are not there in that, which I'll tell you because I have refreshed it later on, at the last moment. Say, and these 3 topics which I gave, which I discussed in the beginning, the Sikkim High Court judgment, the Allahabad High Court judgment, this broken window theory, file and life, they are not there, you will not find. They're from my own perception. Say an eye for an eye makes the whole world blind. This is a very old theory. So you can't have मेरा बज रहा है कि आपका किसी का बज रहा है? मेरा बज रहा है. One minute. Sorry for the interruption. You see, and as I pointed, one should look for what is the wrong. What is the wrong? Who is wronged? And at the same time, instead of saying who is at wrong, see, this has underlining meaning. And then if you look at these from this angle, you'll never alter in your sentences. And don't feel that as a district judge, अगर मैंने life नहीं किया, तो I'll be termed as a corrupt judge. 302 तो मुझे करना ही है. Don't do that. UP we find judges doing that. That even if it's a minor offence, if the charge sheet is under 302, they'll not like to go for 304 part 1 or part 2. No. If it's under the Atrocities Act, they'll give maximum. We have come heavily before 4 days on a judgment where the man is sentenced under 325 of the Atrocity Act. The lady does not even say that I belong to so and so caste. The charge sheet is laid under 325. The judge doesn't even look at it. And a nice reasoning is given that 325 can be invoked retrospectively. That he should be in knowledge that she is of so and so caste. And as judicial officers, this is what my brother has written in his judgment, not this one, another. The testimony comes, he came, he molested, till that okay. He asks me my caste. A man who is in lust, who wants to have illegal, I would not say it illegal, but who is said to have, because there are lady judges, I cannot use those words which I use there, but who wants to have an indecent thing with a lady, is he going to ask her caste? Who will ask? When he wants to fulfill his lust, the judge says he has asked her caste, therefore he knows that she belongs to this community and therefore this act is done. 325 is done. The man is languishing in jail since 22 years. No, this judgment of mine during COVID was in All India TV also, that the man walks free after 21 years. Right, that apart. So as far as your sentencing is concerned, it should have the theory of eye for an eye is not the answer. The word is live and let live. Is that a common law justice? See, as far as our legislation is concerned, legislations are concerned, you will not find any sentencing policy. Though there were several committees which have been constituted time and again, latest being that of Madhav Menon, which have said that you should have some common agenda, but it is not there till date. judicial guidance is given by judges. From 2003, the first was Malibat Committee, which was requested to give a sentencing policy to India. They did not give. And therefore, you see this wide discretion left to us as judges causes problems at times, causes quandary in our minds also. You have to point out new things, new days. Say for example, when IPC was brought onto the statute book, you had not even dreamt in 1860 that we would need a law which would be known as cybercrime law. Who would have thought? Nobody. Say, pandemics, environmental law, nobody had thought. And therefore, I put it very simply. Say, I don't take my colleagues towards the Upanishads because Dr. Mohan Gopal says judges should not rely on Upanishads, they should only rely on Constitution. Fine, you rely on Constitution. But does Constitution have all answers for you? This was a debate between him and me in one of the sessions where we, as a young judge, I had gone, and it was of family court. He posed a question to us, which I am posing to you. इसमें क्या sentence क्या करोगे वो उसके husband को? See, a simple question was put to us, the entire house, that the husband and wife go for a movie, come home walking. The husband at night says, I would love to have beer. The wife offers a beer, they sit there, then he demands at night. The wife says, no, sorry, you are inebriated and I am too tired today. The husband slaps the wife. The wife in haste runs to the police thana. What would the house do? What are your opinions? We unanimously said that the police officer should not register an FIR, should try to resolve the issue because it had happened in spur of the moment. Dr. Mohan Gopal says, what about her constitutional right? I said, what is her constitutional right, sir? To get the husband punished, come on the streets, then go for beggary allowance under 125? Is that what the Constitution says? Where is her dignity? Then he says, what about her dignity? What about her dignity? Then I was overruled to him. You are talking about the lady's dignity. What was the fault of the husband? Was he not right to ask for consummation of the marriage? No, he was inebriated. You are absolutely right. But then what at the end? So here comes your thought process, as a human being. Do you want her to go? See, once the FIR is lodged, what happens? What happens? The man is behind bars. Can you then resolve the issue? He's going to tell, thank you, sir. Usko kaho, jahan jana hai jaye. So she loses her matrimonial house. Matrimonial house is already gone. The moment she walks back to her family there, उसकी भाभी बोलेगी, तो थी ये वैसे, पहले से ऐसी थी. That will ruin her family life there. Then she comes to you as a lawyer. The lawyer will tell, Madam, आपकी भाभी ने भी निकाल दिया मुझे, पर इसकी सिस्टर को आप फंसाओ, 498 लगाओ. The sister is in America, does not even interfere in your affairs. So one slap leads to what? Burning of the whole house? Is that what the Constitution tells? Is that what the sentencing policy tells you? No. You have to use your brains as a judicial officer. So what I mean is, okay, fine. You have come before the court for a trivial offence. Should the punishment be so harsh? The answer is no. Now we go ahead again. The Maliban committee even said that predictability in the matter of sentencing is a thing which should be done. See, again a draft national policy was sought to be brought into effect. That was also in 2008, about 15-16 years back. We have been only talking about having uniform policies since 2010. But we do not have any. And I don't see near future of having any such policies. See, when does your dilemma start? When does your dilemma start? ट्रायल चलता है तब तक तो कुछ डिफिकल्टी नहीं है ना. यहाँ से कल घर जाओगे तो सोचेंगे जजमेंट लिखवाना है, जजमेंट लिखवा दिया. डायलेमा कब चालू होगा आपका? डायलेमा कब चालू होगा? There are small questions which are very easy to be put. The dilemma starts the moment you start pinning down your judgment. Your trauma starts the moment you hold him guilty. Then comes, what should I do? बहुत गरीब आदमी है, इसको 2000 का फाइन करेंगे तो भर तो नहीं पाएगा. Now as a judge, default sentence, can you say no, if you don't pay fine of 2000, remain in life throughout, can you do that? There your dilemma comes. Though this is not in the topic, there is one topic which is to my heart. Section 125(3). There, Section 125(3) of the CRPC has caused lot of problems for the judiciary. Lot of problems for the judiciary. I'll take you to that later on. Now you see, there were two offences. There are two persons in your court. That for similar offences. What do you do? Go to your past. Go to your past. Maybe in one matter of theft you have punished a person for 3 months. The other theft you have punished for 6 months. Why? Maybe the gravamen of theft is more. So you have to go by the gravamen. Gravity. Go by the gravity of the offence and not the nomenclature of the offence. Robbery is robbery. Theft is theft. Say, as I put it, 395 dacoity. At times, dacoity with murder, or simplicity in dacoity, will give you a different perspective altogether. The disparity will now come. There were 5 people charged under 34. Can you say कि नहीं नहीं X ने डंडा ही मारा है तो मैं उसको 2 ही साल दूंगा? The Supreme Court says no. 34, if you are invoking, all take same responsibility. The Supreme Court of India has tried to remove disparity in sentencing by observing that by proper balancing between aggravative and mitigating factors. This is what I have told you. Mitigating and aggravating factors. These has to be seen. What are the mitigating factors, mitigating circumstances? What are the factors which aggravated the situation? As I told you, this question which was posed to us in the appeal, the man was infuriated कि तुम इस बागबान में, in this garden, you are harassing girls. They intervened. But the poor fellow is in jail since 15 years. See, the Supreme Court has said what are the offenders committing similar offences, will you give them different treatment? The answer is no. Now, what do you understand by the word of individualization of punishment? Can somebody tell me? Say, individualization means instead of fitting the offence, the sentence should be fit. Sentence should be fit. That's the theory of Bentham. वो है maybe notes में है, you may not note it down. It's there in my notes, page 4. See, area of punishment under the Indian Penal Code is an exact answer to what Bentham has said. Individualism. So what time do we take a break? 11? Whenever the house is feeling that we want to have a break of 5-10 minutes, we can do it. So this is very important. You see the 17th report of the Law Commission. I just read it inverted commas. A proper sentence is a composite of many factors. Page 4, you may read page 4. Including the nature of the offence. So the main aspect is nature of the offence. The circumstances extenuating or aggravating of the offence. And most important is earlier criminal record. बेल में आता है ना कि सब पहले का कोई रिकॉर्ड ही नहीं है, ये आदमी बहुत सज्जन है. अच्छा सज्जन है तो ये क्यों किया? तो गलती से हो गया. अच्छा 2 करोड़ रुपया गलती से खा गया हूँ. अच्छा गुड. And then sprangs the AGA, the sprangs the government pleader. कि sir, this is not his first offence. This gentleman is the 10th to be defrauded. And see, your entire perspective changes. Had it been first, it would have been slightly lenient. And he would have given bail कि भैया ये 2 करोड़ में से 1 करोड़ भर दोगे तो आपको घर जाने देता हूँ 20 बच्चों के पास. the age of the offender. The age of the offender. Now this comes. The background of the offence done. See, अभी आजकल वो WhatsApp कॉलेज में आता है किसी जज का. When the boy steals a loaf of bread, WhatsApp कॉलेज में बहुत आया है, मेरे पास आया है, I have saved it. Where he is brought, FIR is lodged for theft. The judge asks, why did you have to steal it? The boy says, I was hungry. You could have bought it. The boy starts weeping. I cannot buy. I don't have money. You could have asked your mother and father. He says, my mother is suffering from cancer. The judge says, all sitting here will pay him 10 rupees to buy the loaf of bread. And he starts himself. Whether it's a true story or not, I am not on that. But this is the background where, before punishing the young offender, with reference to education, home life, sobriety, social adjustment, the emotional and mental condition of the offender. Mental condition. A man is said to have. अभी बाद में हम सब साथ लेंगे. मेरे लिए अकेले के लिए चाय लाता था, इसलिए मैंने बोला. The gentleman slaps a person. The judge asks him why. He said, mentally disturbed. What is mental disturbance? So you have to see that also. Mental psychosis of the man. Unfortunately, under the adversarial system in India, under criminal jurisprudence, the accused is not supposed to speak anything. और आप लोग तो अभी नए जजेस है. When we started under 313 also, वो बेचारा कुछ और बोलेगा तो उसका लॉयर बोलेगा तुम ज्यादा मत बोलो, सीधा जवाब दो. See, there comes this predicament. The possibility of return of the offender to normal life in the community. Say 498. Let's forget all other sections. 498. It's not coupled with 304 part A, part B, anything. You sentence him. Fine. The poor fellow says, कि sir, मैंने एक पैसा दहेज का नहीं मांगा. No. He comes up with you before you saying all the datas. The wife says, sir, we want to cohabit. The lawyer said, how can you cohabit? Sorry, what about my litigation? See, this is a multiple chain of litigations going on. So you don't even want him to come back to the society. Once he goes there for 3 years, what happens of his life? Yesterday we sentenced a person to sentence undergone under 304B. When we were told that he has 3 children, the lady had committed suicide after 10 years of marriage. The fellow says the cause was so and so, so and so, so and so. Are they not mitigating circumstances to lessen his sentence from life to? We took a bond from him that on going out, you look after your children. The lawyer told us what, sir, the rigorous punishment which he has been given. See, we are under an illusion that simple imprisonment is better than rigorous. But it's other way around. Why, If you sentence a man to simple imprisonment, he does not get those remissions. He is not permitted to work. So he will not get remuneration, he will not get remission. उसका पूरा पैसा जो वो कमाता था बच्चों को भेजता था. This is not enough mitigating circumstance to lessen his sentence. And we found, yes, this is one of the mitigating circumstances. What purpose will it be now kept keeping him in jail? He has already spent time of his life. He is repenting. He has lost his wife. We don't know what the fate of the children is. So at times you have to see with human heart also while sentencing a person. The possibility of treatment or training of the offender. The possibility the sentence may serve as a deterrent to crime by this offender or by others, and the present community need, if any, for such a deterrent in respect of the particular type of offence involved. So you may not show any mercy on a drug peddler. Then you can go to my article on sentencing policy for NDPS criminals. See, when does your obligation to sentence him start? When does your obligation? The simple question, simple answer. Don't think too big about it. The simple question. It's like 1 plus 1 is equal to how much? You don't say 0. Like those mathematicians. You say it's 1 plus 1 is 2, sir. It's like this. When does your obligation to give appropriate sentence start? A simple question.
Once you have decided that he is a con, once you have convicted of a
Yes. Not convicted. When you find that the man is guilty of an offence. Once you find he is guilty of the offence, with preponderance, you are sentencing him. Once you sentence him, what sentence? Then comes your headache. And as I told you, wide discretion is given to you. Now you can take this 1976 4 SCC 190, page 5 pe I have given the name, Santa Singh versus State of Punjab. Give this example of theft. You go to section 379 of the Indian Penal Code. Man is said to have committed theft of 5 rupees, or 5 lakhs, or 5 crores. The sentence which he is supposed to be handed over is 3 years maximum, or fine. All both. Can you say कि नहीं 5 रुपये की चोरी किया है तुमने तो भी तुमको 3 साल, तुम 5 लाख ले गए तो भी 3 साल. Can you do that? So there comes the problem. There comes your guidelines which are given in Santa Singh versus State of Punjab. And section 235 and 248 of CRPC should be gone into. or giving a proper sentence to the person. Now let's talk about types of punishments which you can give. What are the types of punishments which you can give? One more you have forgotten. Read it. All that you have read. The main you have left out. Death imprisonment you have left. And one more which has been now, which progressive judges like us, which is your third topic, section 360, 361, read with Probation of Offenders Act. This is normally done when we grant bail, you know. At the time of sentence, it's a bit less. Communitive service. And you remember Justice Pathak telling in one of the orders, he had said community service in a hospital for 2 days in a week to this fellow. Now what happened? Even after the bail, when the trial, everything was going on, this fellow comes once to the judge's chamber. The judge asked, what happened? Abhi wo jate ho ki nahi jate ho? Because the judge had stipulated that he will report once in 3 months to this court also, with a report from the center which I have sent him. The judge also had a hearty laugh. See, at times, even in Sikkim this would have been, say, the dialects of each district would change, you know. I don't know the local language, but the dialects would change. Say, you speak a language which he may not be able to exactly understand. So a patient coming from Gangtok to Namchi or Namchi to Gangtok may not be able to converse properly with the doctor. So this fellow was doing local language. So the doctor will ask him, what is he saying? So he said, sir, during COVID, I was called every day. And the patients now have started feeling, I am a doctor. और मेरी इज्जत इतनी बढ़ गई है that you may change this 2 days to 6 days a week, I don't mind. Say, so this is a reformative thing in the man. You know. When I heard this from Justice Pathak, I said, मैंने community का तो किया है पर ये reporting to the court नहीं किया था कभी. Now let's go to chapter 3 of the CRPC because that is one of our topics. Yeah? Yes, yes. नहीं बाहर चले सबके साथ यही बैठते 5 minutes and you can put your questions during that time while having a cup of tea so that we are talking about say CRPC and there you have one Supreme Court which is vested with all powers, all pervading powers. Any sentence is authorized by law. And as I put it, 142 is the Brahmastra for them. Article 142, they can do anything. High courts, any sentence authorized by law as per section 28 of the CRPC. Now comes the role of session judge and additional session judge. Any sentence that is authorized by law and you have powers of death sentence, but that has to be confirmed by the High Court. under section 28(2). Now I think after the Shetty Commission, we don't have any judges in the realm of assistant judges. So assistant session judges are no longer there, practically not there. There you have imprisonment for 10 years, powers. Then comes your Chief Judicial Magistrate. He has the power of imprisonment up to 7 years. All fine. Judicial Magistrate, 10 years, 3 years and 10,000. Now what if a Judicial Magistrate gets a matter and feels that no, here the punishment which is to be inflicted has to be more than 3 years. What is the cause? Does he have any powers?
He will have to refer the matter to the CGM.
He'll have to refer the matter to CGM.
He sends the matter to the CJM. He says, I have held him guilty, but I cannot punish him beyond 3 years. I cannot punish him, I cannot fine him beyond this. So please do the needful. Because Judicial Magistrate first class has power of 3 years and 10,000 as per CR. What is if fine is not paid? Can the default sentence, no, yes, you sentence him for default. Can the default sentence be more than the main sentence? मेरे को 3 साल की सजा आपने कर दी, फाइन 10,000 किया, फिर आप कह सकते हो 10,000 नहीं भरे तो 3 साल जाएगा अंदर. Can you do that? Normally that has to be proportionate. See, section 30 is very clear. Now, the last, is there any principle of estoppel applicable to criminal jurisprudence? किताब में मिलेगा, किताब बंद करो, बिना पढ़े कहो. Is there any principle of estoppel? Just visualize. I am putting it complicated to you so that मेरा importance लगे. लगना चाहिए था. स्कूल में टीचर अगर complicated question नहीं देता है तो उसकी importance क्या लगेगी? If I put you simply, what is the principle of double jeopardy? So that we have read it, we have examined it. If it is in a twisted way, principle of estoppel under the criminal jurisprudence, is it there or not there? I gave you the hint. What is it? Now turn to page 9. You will find the answers there. And the judgment of Monica Baby. I forgot to tell you the minimum sentence celebrated judgment of this, क्या नाम है, cricketer, Navjot Singh Sidhu. Just go through it. A recent judgment reported in 21 or 22. Unfortunately, I have not taken it in my notes. It's there in my pen drive. And there's Monica Bedi versus State of Andhra Pradesh. (2011) 1 SCC 284. Now see, this estoppel issue cropped up in Pritam Singh versus State of Punjab, 1956 Supreme Court. And we are over enamored with Latin maxims, हम लोग जब लॉ पढ़ते थे तो एक पूरा 25 मार्क का आता था मैगजीन्स, लैटिन आए ना आए वो बात अलग है, तो ये आना चाहिए। एंड जजेस ऑफ हायर जुडिशरी फील कॉपी पेस्ट पे ये तो कहीं तो होना ही चाहिए, तो ही आप इंटेलिजेंट हो, वेल रेड हो, ऐसा होना चाहिए। As I told you in the beginning, I am not a critic of Krishna Iyer. I love him. But would you like to read a Krishna Iyer's judgment? Or you would like to read a judgment which is as simple, explaining things to you, sentencing क्या होना चाहिए? Autrefois acquit. What do you understand by that? Let it be examined. Page 10. A defendant's plea stating that he or she has already been tried for and acquitted of the same offence. How many of you have seen that movie Three Idiots? All of you? वो beginning का scene है, देखा है? नहीं, क्लासरूम में होता है, वो बेचारा सिंपली समझाता है उसको, नहीं वो बाद में, वो सिंपल पूछता है जब प्रोफेसर, and he answers it in the simplest of simple words. The poor fellow is told to get out of the class. The idiot comes back. अब क्या हुआ? And then answers in a very overcomplicated manner. And the professor now asks, कहना क्या चाहते हो? Simply कहो. The fellow says, मैंने simply कहा था पहले. नहीं, ये मूवी मैंने फिर से परसों ही देखा, इसलिए it is ripe in my mind. And seeing that scene makes me go giggles like anything. That this is judiciary. You talk simple and you are scorned. And you talk complicated and the judge is acclaimed. Ah, what a learned man he is. तब कहता है ना कि सर बैग छूट गया, बैग लेने आया हूं. The fellow says मेरी बुक्स या बैग रह गई है. The fellow says, why did you not tell it simple? I did that and I was thrown out. It's as simple as it is. Therefore, had I said a simple word, you would have said, ये तो हम सबको पता है. See, in this case, one Vikram Singh was prosecuted under the Arms Act for possessing a revolver without holding valid license and was acquitted by a competent court. He was subsequently tried on the charge of murder. The accused was acquitted since the evidence of recovery and factum of possession of revolver could not be relied upon by the prosecution as he had already been acquitted by a competent court on that charge. You want some? So why this logic? Here he was charged for murder. But the thing was, he was charged of having committed murder by this murder weapon. Now when he was already acquitted much longer before, कि ये revolver ही नहीं है उसके पास, ये नहीं है, then how can you convict him on that? Now one more aspect. भैया पढ़ने का नहीं वरना आ जाएगा सब. Is the principle of res judicata applicable in criminal jurisprudence? At a flash you will say no. सर वो तो सिविल में हम सीखे हैं, ये कहाँ इसको यहाँ ले आए हुआ? There is a big word, res judicata pro verieta acquitor is no less applicable to criminal than to civil proceedings. Page 10 of the compilation. Now you even have this apart, you have even said, that is what I told, if I tell you in simple words, you will say, sorry, this we have read in section 300. Section 300 of CRPC also speaks about double jeopardy. Constitution also prohibits double jeopardy. Person convicted of an offence constituted of any may afterwards be tried if consequences take place subsequently, which had not happened at the time when he was convicted. It's a simple thing. The illustrations are also very clear. I hope I am audible to people online. Yes or no? Both of you, am I audible? Okay.
Yes, Rajat.
Thank you, thank you. See, why? Why is this so? Say, a man is injured. FIR is under 307 or 326. He is tried. And you have a very fast judge. You convict him within 20 days. Fine. After 50th day, out of the consequences of this injuries, the man dies. Can you retry him or not? Is it for the same offence? It is a consequence of his acts. I think I am clear on section 300's interpretation. Young man? Madam? Now, as I told you in the beginning, we have discussed 5 kinds of sentences. Can compensation be part of punishment? Can you say it is a punishment? Or not? वो उसमें नहीं मिलेगा, वो पढ़ोगे तो नहीं मिलेगा, वो कॉम्प्लिकेटेड लिखा है इसीलिए.
Punishment will be fine.
You can substitute fine. You can say I am fining him 1 lakh of rupees, out of which 95,000 will go as compensation to the victim, 5,000 to the government coffers. 357, and there is a new amendment 357A, based on the victim compensation scheme, you know. And you see, the Supreme Court has said that compensation is in addition. It's in addition. You are not substituting it. It is not ancillary. Substituting. So that is what exactly in Ankush Gaikwad they have said. Say, let's go to Indian Penal Code. You have section 53 to 75 which discusses about types of punishments, namely chapter 3. I will not threadbare go with that. They are same, what I told, what we discussed. Death, penalty, punishments, simple forfeiture of property and fine. Now we go to the last leg of our first topic, and it will not take long. Consecutive, concurrent. Why this topic? See, at times, Supreme Court has time and again said that as far as possible, go for what is known as concurrent punishment. I had a litigation where the man was sentenced for 99 years at the age of 60. Now what is the purpose of it? What purpose will it serve? उससे तो आप लिख दो ना, till the last breath. That is what Supreme Court tells you. Life means life. Till the last breath. Why say 30 years in this, 30 years in that, 60 years in that? What for? You have Dilbaz Singh versus State of Punjab. AIR 79 to SCC 103. Recently, in OM Chevai versus State of Kerala, Manupatra /SC /1003 2014 has affirmed that in case where the court does not order the sentence to be concurrent, namely one sentence may run after the other, in such order as the court may direct. There it has been clarified. It gives you full discretion. Whether concurrent or consecutive. Say, there is a distinction under section 31 also, where a man is punished for one or more offence in the same trial. Then it gives you the leeway whether to order concurrent or consecutive. How will you decide? How will you decide that it should be concurrent and not consecutive? Normally be on safer side and give consecutive. That is what the Supreme Court tells you, time and again. Now let's go by the judgments. The recent judgment in Sunil Kumar, you can turn to page 18 of the notes. So that is a full answer. It is already now a reported judgment. Then you have Muhammad Shahid again. Now, as I have been telling you, though the topic of NDPS is not with us in the curriculum which is given, turn to page 19 and go to section 427 of CRPC. No leniency should be shown to an accused who is found to be guilty for offence under NDPS Act. You have to see this interest of the society at large. See, earlier, before you people came in judiciary, yes, even before you came, the NDPS did not have segments. All matters would be tried by sessions court only. And the minimum sentence was 10 years and fine of 1 lakh. Even if you are found with 1 gram, 2 gram consumables, there was no distinction between commercial quantity or private consumption quantity, no. Then came this, that lesser sentencing would be with the judicial magistrates, then with the session judges. So that was based on the theories of punishment. Then you have this judgment of Vicky. Gentleman, a very gentleman. See, only if the court directs that the subsequent also will be concurrent. Otherwise it will be consecutive. That also again you have to look into the antecedents of the man, the status of the man. That is what is said in Vicky while granting probation also. Just go through that judgment because we are short of time. I have still to take 2 more topics on that. Then you have VK Bansal, whether it should be concurrent or not. Omecheven, which I told you in the beginning. Now, the last in this first lag is your minimum sentencing. I had discussed with you the first judgment of the Sikkim High Court, which if you get the copy, if you download it and go through it, mandatory, you see, we need not discuss much on that because once there were 2 kinds of minimum sentences, you see. One, where you have not been given as a judicial officer or as a judge any power to sentence below minimum. So there were certain provisions where minimum is prescribed, 6 months, but you have been empowered for the reasons to be recorded in writing. The judge may grant punishment below minimum. So I'll give you a very simple example of my earlier days of judgeship. in Gujarat, all of you know, there's a prohibition. There's prohibition on sale, consumption of liquor. Now, in my young days when I was a lawyer, our seniors would tell, भैया वो अपना ड्राइवर है, कल पोटली पी के पड़ा था वहीं, पुलिस ने पकड़ लिया है, उसको आज पेश करेंगे कोर्ट में, उसको कह दो गुनाह कबूल कर ले, जज साहब उसको बिठा देंगे, पूरा दिन एक कोने में बैठने को कहेंगे, ये 100 रुपीज ले, वो भर नहीं पाएगा, तुम भर दो. See, this was what was prevailing, though there was minimum sentence of 3 months. One fine morning, see, as I told you, we are judicial officers, so all my judges kept all these matters in the Lok Adalat. Sentenced them to admonition, this, that, and did away with it. One sumoto lordship took up the matter, quashed that order, held the High Court should hold inquiry against this judge. Such shortcuts should not be where there is minimum sentence prescribed. Don't take such shortcuts. And the judgment went into 30 pages. Now which judge will take the risk? Will any judge take the risk? If you are a lawyer, will you tell your client, भैया कबूल कर लो, 3 महीने जेल होके आओ? Will you tell that? So what happened is, these cases started piling up. Gujarat, if you have seen the border, I am on this exactly on sentencing policy on minimum sentences. At times, it was counterproductive to your justice delivery system. Gujarat is surrounded by 4 states: MP, Rajasthan, Maharashtra and Pakistan. We are surrounded in this. Now, this labor people will come from Rajasthan, Maharashtra, MP. And what I call it as consumption. That desi thaga, you understand desi thaga? वो पी के पड़ा होगा, उसको पकड़ ले जाएगा. Now, which lawyer will tell him? Which lawyer will tell him that you plead guilty and go for 3 months in jail? The lawyer will take his fees for bail, get the man out of bail, on bail. The fellow will go away to MP. आप जज की हैसियत से ढूंढते ही रहो, नहीं मिल रहा है. क्यों? एड्रेस उसका होगा गैंगटॉक का, चला गया सिलीगुड़ी, कौन पकड़ने जाएगा? Thereafter I told my Chief Justice के सर कुछ कीजिए, ये जजमेंट हटवाइए. On judicial side, we'll do something then. Fortunately, that judgment was watered down. We got what about 8 to 8 lakhs matters disposed of by withdrawal of those cases. See, this is what is, when you are too harsh, when the powers are given to a judge to assign reasons under the Prohibition Act itself of Gujarat, you say no, hold him guilty. वो तो घूमता हो गया, मेरा जज फंस गया बेचारा. So that is where I call it as and this judgment of our High Court is very well penned. You need not go on any other judgment on minimum sentence. And of course this 2016 AIJEL SC 59617 Muhammad Asim versus State of Uttar Pradesh. So in state of Madhya Pradesh versus Vikram Das, reported on 8/2/2019. This is repetition of the earlier judgments. When the legislature has prescribed a minimum sentence, now the bench ends without discretion. Without discretion, I am very clear. The same cannot be reduced by the court. In such cases, imposition of minimum sentence, be it imprisonment or fine, is mandatory and leaves no discretion to the court, quote unquote. Now we go to the second last leg of the topic. Meaning of the term life. What do you understand by the word life as envisaged? Minimum sentence I have taken, consecutive I have taken, concurrent I have taken. Yes. What do you understand by the word meaning life? Then I have a difference of opinion with many of my brother judges. And it's a radical view which I have started since 2013, and unfortunately all those judgments have been upheld, but the Supreme Court has not come up with any theory on that. Yes, earlier you said life till the last breath, you know. Now if you see the celebrated judgment of Vikas Yadav, honor killing, then the Supreme Court said no. We substitute death sentence to 35 years without remission. So if you say that in a gruesome matter, where the man is to go to the gallows, you say no, not till last breath, 35 years is fine. For non-heinous crimes, why can you not have a fixed term over 14 years, anything between 14 years till the last breath? Say this is my radical thinking based on Vikas Yadav, and nothing shy. I have given about 7 judgments on that. 3 of them have been confirmed, 3 they have not gone to the Supreme Court, where I have said that yes, 14 years is minimum. You don't want to use your powers of remission. You have not used them for 20 years. Why should I now give you the power? Why not I use Vikas Yadav and give a fixed term to this man? Let him walk free after the 20th year of his incarceration. And the power of remission under 433 is vested with the government. The words used are imprisonment. There's one word, imprisonment. And then imprisonment for life under certain sections. Say under 326, you give a leeway. Life bhi hai. 304 part 1 mein life bhi hai. The only section where you don't have discretion is 302. Imprisonment for life and or death. There the Supreme Court has interpreted that imprisonment for life would normally mean, as per section 57, it stipulates 20 years. If you go by section 57 of the IPC, do you have the book? Book है IPC का? किसके पास है? किसी के पास नहीं. calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. Now therefore, where do you get this theory of life till last breath? This is my research work, that this theory of life till last breath came in most of the matters where the man was sent to gallows. Death sentence was given by the trial judge, the High Court, the Supreme Court feels, no, he will not go to death, he will not be given death sentence, he will be sentenced to undergo 25 years, 30 years, 40 years, looking to the gruesomeness of his sentence. Yes, of course, you have not been given these powers, as recently said by in one of the judgments. आपको तो लाइफ करके छोड़ देने का, रहो भैया, हाई कोर्ट करेगा जो करने को. There, a very old judgment of Justice Krishna here speaks volume, which is known as a judgment known as Maru Ram. Of course, there the issue was invocation of 433 of the CRPC. Then came Ashok Kumar. When the man said whether it is my right or not, you at least consider my case. You reject it. Thank you. That marks end of the first lecture. Yes, madam. Yes.
You just, with regard to section 57, Lordship,
Yes.
then I just wanted to know how do we compute that in light of section
You're
55, which
not
says-
audible, madam. 1 minute. थोड़ा जवाब का वो कीजिए ठीक से. Yes. Yes.
Section 57, which you just discussed, Lordship.
Yes.
How do we consider that in light of section 55, which says 40 years?
55. 1
life
minute.
sentence.
1 minute. Please give me 1 minute. We will discuss section 55 along with it. Fine. See, this is the powers of remission akin to section 433. This is 57 speaks of fractions, and life imprisonment would be 20 years. That is what is specified. And section 55 is the commutation. So this state government normally cannot commute before 14 years. Am I clear now? Because 14 years, they cannot take recourse to 433. Please go to section 433 of the CRPC also. This has to be read with that, and things would be clear.
All right. Lordship.
I hope I am clear on that, madam.
Yes, Lordship, thank you.
Thank you. Any more questions on this topic? Any more questions? किसी को? And as I put it, दो ही किस्म के लोगों को कोई प्रॉब्लम नहीं होता है. जिसको कुछ नहीं आता है, या तो जिसको सब कुछ आता है. और जिस दिन जज कहे कि मेरे को सब कुछ आता है, then he should resign and go home. Now the second topic which is posed for our consideration is, see, theories of punishment. and purpose of sentencing. So as to narrow the disparity in sentencing. You have to narrow down your disparities in sentencing. And I normally would put it like this. Theories, purpose may be two purposes. Either it is reformative or rehabilitative. Disparity in sentencing, mitigating circumstances, aggravating circumstances and Supreme Court guidelines. Now as you go by the judgment which I gave to you,
Yes.
we have discussed all these theories at length. Now what is deterrent theory? Do I need to discuss it? We have learnt it umpteen number of times. जो मैडम ने कहा ना डिटरवेंट कर दो उसको ताकि दोबारा नहीं करेगा, आपको पता नहीं है डिटरवेंट नहीं होगा। आज एक चाटा मारा, कल जाके एसिड डाल के आएगा, तो हमको 3 दिन जेल में डाला, then what will happen to their children? Just think of this. At times deterrent theory is not the only answer. See, the deterrent theory has two swords with it. One, if you do this, we'll send you to jail. And giving that as an example, you slap her, we are sending you to jail. That is what she said, deterrent theory. How far has deterrent theory worked in India? Has it worked?
Not so.
तो 498A कोई होता ही नहीं ना आज, आपके पास कोई मैटर ही नहीं आता। दहेज प्रथा बंद करो, आपके पास कोई 304 भी आता ही नहीं। Whether old lady dies in unnatural circumstances within 7 years. This is a deterrent theory. Those sections are based on deterrent theory कि भाई don't do this. Despite that, this is happening. See, the theories also said the first purpose was not always served, since the offender could become a more ardent criminal. You send him to jail for a slap on his wife. These are not those offences where he is going to remain in jail for long. The moment he comes out, what will be the reaction? तुम हमको 3 दिन जेल तो भेजी ना, अब दिखाते। I hope you understand Hindi, all of you, most of you. So that is the first theory, and though Samant is a great advocate for deterrent theory, as he puts it, the more efficient the coercive action of the state becomes, the more successful it is in restraining all normal human beings from dangerous paths of crime. Now let us take the 21st century. You have come out with all kinds of deterrent actions against people siphoning away your bank accounts. Toby, I am giving you my personal experience of this last 1 week. My son got me an HDFC account, recently opened. I've been getting a message from different phone numbers since 4 days. आज एक तो आज ही आया है. Just read it for you, if it's still there. I have never done any transactions with a debit card. Your OTP for debit card ending is so and so. Use this as HDFC Bank immediately. And now comes. Create the ATP pin and upload your PAN card details. So I wrote to my son. And I, of course, this was, dear user, your HDFC Bank account will be suspended. मैं अभी कल तो खोला है. Suspended. Today, please update your PAN card number. Click here. So I asked my son. So he said, appears to be fake message, Dad. Please don't respond. I'll confirm with bank manager. So my answer is GG. Then comes, kindly ignore. Message from our bank manager that this is a fraud message. So I said, I also had called the bank people. They also said, please ignore. So आज सवेरे भी आया है कोई और नंबर से. Asking my Aadhaar card to be linked. Is there any deterrence? Where do you get deterrence? And what about retributive theory? What do you understand by the term retributive? Against which I told you in the beginning, an eye for an eye. It's still in vogue in the Eastern countries. But we don't have that retributive theory. So no need to discuss it at length, because you will not find any judgments on that. Rather, there is a lot of criticism on that theory. The two theories which India professes is, one is preventive theory, and then the last is your reformative theory. You are supposed to reform them now. And as I put it, after a lot of my study on the jail analysis, jail menus, after the 10th year of his incarceration, he is a burden on you. Why you? We are also citizens of a state. We pay taxes. After his 10th year, you see his health gets started deteriorating. Sikkim may be a smaller state where you may not have these many problems about all these criminals. Take UP. I was told by one person, for 1 month, the jailer charges from the family 80,000 rupees. For what? Can you imagine what? Not for the facilities. वो जो movies में facilities देखते हो ना MP MLAs को मिलती है, वो नहीं. For a bed at night to sleep, because the jails in UP are overcrowded. Reformative theory. How is it defined? And the main now to which I would take you to is the expiative theory. You have to club these two in this modern days. Reformative theory with expiatory theory. Expiatory theory is the base on which is said punishment should be to adjust the suffering to the sin. Take to page 4 of the second chapter. Guilt plus punishment. And this was in vogue even during the Mahabharats. This theory in India was there. Now, with due respect to the Supreme Court, we should not normally comment on anything done by the Supreme Court because we are not supposed to, unless you are a research scholar. They have also been within your limits. Because after all, you are a judge. How they will view, you never know. I have 2 instances which I can share with you. I had a very personal friend of mine. He was also a prolific writer the way I write articles. But he would write articles which I call not critical, but a critic of a judgment of the High Court. And at the end he would write, had the lordships used their so they would not have committed the mistake. The libraries are at their command now. So मैंने एक बार उसको कहा, as a personal friend, and he would always comment कि तुम इतना अच्छा क्यों लिखते हो? Why do you write this? I said, my articles are analytical. And as a judge, my father has taught me something different than what. Why I am telling you this? Because you are upcoming judges. You don't know what comment or what critic in any of your articles or any of your judgments may hurt whose sentiments. Hurting sentiments hurts your career also. This happened to this gentleman. 3 times he was warned. He didn't mend his ways. Ultimately he had to face the music. Then the High Court told, हमको लिखते नहीं आता है, अब तुमको सिखाते क्या लिखना है. And when I was doing my thesis, there was one absolutely wrong judgment. So I wrote, Lord, my dad would correct my thesis at night. So when I woke up in the morning, पूरा काटा था. मैंने लिखा था, this judgment is against the mandate of the Supreme Court. The learned judge should have seen this. This is peri materia with this judgment. सब जो कहते हैं ना Latin word, he used one Latin word. The judgment of the Gujarat High Court is per imperium. You cannot call a mother husband's father's wife, you know. You have to call a mother a mother. It's a decent way. मेरे बाप की बहू है. Will anybody like it? Tomorrow your son coming and telling you, oh, you are wife of so and so. You are not going to tolerate it, even if it is your son. Will your male chauvinism permit you? 3 of you, 4 of you sitting here. तुम तो मेरे माँ के पति हो. Nobody likes it. So you have to be temperate in your sentencing also. Be firm, but don't be harsh. Be harsh, but don't be rude. Be rude, but don't be unethical. Be unethical, but don't be illogical. This is how I put it. Now, what is the purpose of sentence? We have to again go back to these theories. Purpose is deterrent, purpose is retributive. Page 6. Why reformative? All these judgments from 2010 till 17 I have referred. Now there is a theory which has come up known as rehabilitative theory. And you may say, हम judges को उससे क्या लेना देना है? But that's a theory which we'll have to look into. Rehabilitative theory. Say, why rehabilitation? What for? Say, for example, as a JMFC, you have convicted a drug addict. Is punishment the only thing which he needs? The answer is a no. You have to send him, you have to convey that his sentence would also be rehabilitative. Of course, this is a new era. You'll have to take a stride ahead. You'll have to think over. The word is know thy judge. So you'll have to see whether doing that, what are the repercussions. You have to exactly see that. And whether it is good for the offender as well as the community at large. So there were disparities in sentencing. Justified disparity is also there. What do you call by justified disparity? What is the meaning of justified disparity? Justified disparity क्या कहते हो? How will you term it? How will you explain it? And why is it good? You say, sir, एक बार तो आप कब से लेक्चर दे रहे हो? There must be sentencing policy. One stage you are saying there can be disparity. Why disparity? And why do you justify it? See, justified, why do I call it justified disparity? Or why does the legislation permit you justified disparity? It is on the seriousness of the offence. As I discussed in the beginning, theft of 5 rupees, theft of 5 lakhs. So this is a disparity. Had there been a straitjacket formula that for every theft the sentence will be 3 years, is it going to be of any conducive nature? Not giving you leeway. Then it would happen what was happening in Punjab those days. Every third judgment of old days you see, on technical grounds, the accused would be let off. Why? The minimum sentence was 10 years and 1 lakh. अब 1 ग्राम खाते हुए पकड़ा तो भी 10 साल भेजो. So most of the judgments of Punjab Haryana High Court in those days of the trial judiciary was acquittal judgments on technical grounds. That is disparity. So justified disparity arises on the basis of grounds of offence, seriousness of the offence, number of previous convictions, and age of the deceased, age of the accused. So now turn to page 9. So what time do we want to free them of the burden? No, still they are not bored, so they can withstand for some more time. One is fine or two is fine? This is disparity again. One or two? One. अबे बीच वाला बोलते I think you can get this also. This is from the book known as Thus Spake Their Lordships. It's a very good compilation by EBC. You can have it for yourself in your libraries also. It's on all the topics where the lordships have said something great. On each topic, this book is very good. It's in one. The second edition is up to 2018. And if you see the Supreme Court Cases Digest, अगर आप लोगों ने देखा है रेड कलर का जो डाइजेस्ट होता है, उसमें उसका एक फीचर आता है quotable quotes. In each volume you will find that. So this is the book which EBC has a nice marketing strategy. See, now this is where you cannot have a sentencing policy in India, because disparity goes to the heart of the sentencing theories. And if you don't have justified disparities, you will have all difficulties. Say like Justice Dattu told in 2015, undue sympathy to impose inadequate sentence would do more harm to the justice system by undermining the public confidence in the efficacy of law. Recently, I'll just hurriedly at the end give you these 4 or 5 judgments. Do you all have your pen drives? If you want, you can take down the PPT on your pen drives. Because they'll share it by the email. Because it's 200 slides, so had you said 1 till 1:30, I would have run it. As I told you, I normally don't go by my scripted books. I'm not used to. Some reasons which may be taken into consideration as a source of inconsistency or disparity in the Indian sentencing system. This you'll find at page 9 And the judgments therein above would clarify this to you. See, at times, as I told you, the Patna High Court said that judges should have a lecture series in sentencing policy. Lack of guidance is one of the reasons given by the Supreme Court. And therefore now the Bhopal Academy has also come up with this, that each academy should have at least some program on sentencing policy. Because recently the Supreme Court came across this insufficiency of punishment. And just get that judgment within 1 minute. Just give me some time. It is there, I will locate it. Again on page 10, this is bit of repetition. And it's copy paste from some other book. You see, you should have public abhorrence for such criminals also, as a deterrent. Otherwise, as said by many, if you have seen the movie Sikkim, not the South Indian version, the Hindi version, and में कहता है ना 1950 से 2010 तक किसी MP MLA को किसी ने जेल नहीं भेजा है, मुझे क्या भेजोगे? So this is the mindset. Now there is a slight mind change as far as what I call as green criminology. What do you understand by the word green criminology? Any idea? Any idea what is green criminology? नहीं, क्योंकि परसों ही पढ़ा है. I have to deliver a lecture on green criminology at a international seminar on 25th in Bombay. What is green criminology?
Is it forest offences?
Huh?
Is it wildlife and forest offences?
It is basically environmental justice. Say, show me judgments where the criminals are sent behind bars, either under the Water Act, Air Act. Why? And therefore, recently the government itself is shifting towards what is known as compensatory jurisprudence of punishment. This is one new facet of sentencing policies. See, a white-collared person would not like to go to jail. And for that, what does he do? He will first, the moment FIR is lodged, he'll come rush to the High Court for caution. So 10 साल वहां पड़ेगा, caution निकल गया, हट गया. आपने समन्स निकाला, फिर से आया हाई कोर्ट में. The summons issued is without application of mind. So the High Court will again stay. Again 5 years. So the government of India has also thought that as far as green justice is concerned, let us supplement it with compensatory punishments. Not fine. Let me be clear. There's a new sentencing theory coming up in the world. And why I am saying this? Because I am doing my LLD in what is known as compensatory jurisprudence under the Environmental Act. Until date, you will not find a proper theory of what should be the punishment, what should be the compensation for green justice. ये किस पे नहीं मिलेगा मैडम? ये यहाँ से निकला है अभी, इस पे नहीं है. Now Manjit Singh is a very old judgment. The fellow commits 17 murders. Will you show reply for him? Can he be changed? Therefore it falls within rarest of rare cases. Brutal murder. Not out of vengeance. Then the aggravating circumstances and all. Mitigating circumstances is there. Now go to 2012, page 14. These are the guidelines given by the Supreme Court. Jayendra Vashnik, State of Maharashtra. You can please go through this judgment and help yourselves. All these judgments, if you go by the said judgments, will give you a broad outline and you will not falter. That's my promise. Now, if you give, say, a sentence of compensation and he does not pay the compensation, then what? What happens? He said, मेरे को नहीं पैसा देने का. मैं जेल भी गया हूं, पैसा भी दूं, खाए दूं. Sorry. Then the default sentence is there. Now, as far as your negotiable instruments acts are concerned, under 138, earlier the law was very clear that all that you could do is punish him. But now you have even permitted to give double the amount or the amount of check amount once he is held guilty. Usme bhi, with due respect to Justice Balakrishnan, the judgment saying that even in appeal and even while settling the matter, the accused will pay this additional. So the settlements fail. Why should I? He better go to jail. You should adopt the corrective methodology. Keep that in mind. While sentencing a person, keep this in mind. And as I told you, offense must be the main focus, not the man. And let me tell you with utmost respect, कभी ऐसा लगता हो हमको as district judges या तो as सिविल जज जूनियर डिवीजन और एसडी, ये जजमेंट तो बिल्कुल फुल प्रूफ है, इसमें कोई छूट नहीं सकता, उसमें रिवर्स हो क्या आता है। जब कभी लगता हो शेकी है, इसको 5 साल किया है, हाईकोर्ट जूते तो नहीं लगाएगा, हाईकोर्ट नोटिस देता है, एनहांसमेंट क्यों नहीं। सो डोंट बी टू स्कैर्ड, डोंट गो ऑलवेज बाय योर हार्ट, go by both, synchronize both, your heart and your mind. And I don't go by those theories that your heart is at the left but it is always right. And one more judgment which you should all read, as I told you, which is not there in this notes, is Ankush Gaikwad, which I have been following extensively since 2013. See, there was a lot of hue and cry about this post-Godhra riots. There was a matter which was conducted before us. 2 young boys were on the cricket ground. Out of a quarrel, they were done to death. The police gave it a big picture of post-Godhra rioting by one community against other community, this, that. Nothing of the sort was there. The trial court also did not find this as rarest of rare case. It only convicted the young people. Those 4 young boys were also convicted. When the matter came to us, तभी नया नया ये अंकुश गायकवाड़ का जजमेंट आया. And we put forward that if the family is ready to accept money for the loss of the children, earlier they were slightly reluctant. But the other side also belonged to the same family. And the boys were in jail since more than 10 years. At the end of the day, both the parties agreed. And that is how we adopted this corrective theory and Ankush Gaikwad and compensatory jurisprudence. सबको mixture करके we sentenced them under 304 part 1, undergone with compensation whatever amount. So that marks the end of our second topic. Now I would, before I embark on the lecture 3, I have begun with it on a short note of Probation of Offenders Act and Section 360, vis-a-vis each other. I gave you the idea of community service. Can that not be a good ground of invoking Probation of Offenders Act? What is Probation of Offenders Act? To life convicts you cannot. उसमें बड़ी हिम्मत नहीं करने का. So in the matter of Govindan versus State, Criminal Appeal number 1665 of 21, quantum of sentence. Now again you see, this quantum of sentence is all repetitive of what we have done in the first 2 lectures. It is sum total of what it is. What is quantum? The period basically. All fine. What you would impose. The facts that gave rise to the instant appeal were that there was a civil dispute between the complainant and the accused relating to a pathway. that led to the land of the complainant from the land of the accused. Civil suit was there. Appellant stabbed the deceased. Now there was no premeditation. No premeditation. So then you have this KP Singh forming a uniform sentencing policy. Now this takes us to the quantum. Turn to page 3. Why quantum? Sentence in cases of conviction of several offences at one trial. So this is again what I discussed with you as far as first topic was concerned. Consecutive and or concurrent. Commence the one after the expedition of the other. Page 3 of the third lecture. Section 31 and 71 are clear on this topic. Now you have the guidelines, This is that Sikkim judgment, madam. हमको दिखाओ. Which is given. Dhananjay versus Dhananjay alias Pappu. Don't go by the word Pappu. See the discretion not to punish. Why? On what basis? Why should I not punish a man? What for should I permit him to go scot-free? Why? When I have been given the power, when I have been told that if he is guilty, punish him, then why do you teach me not to punish? There the theory of reformation comes. And that is where your Probation of Offenders Act vis-a-vis section 360, 361 comes. And therefore this topic. See, at times the offence may be of trivial nature. As I told you, a minor boy robbing a loaf of bread for to see that his mother survives. Will it be beneficial to the society at large to send him in jail or the reformative home? Rather, it will have a deleterious effect on his life and his entire family. So forget a 10-year-old child, an adult son is forced to do this out of compulsion. Now you have the 1958 Probation of Offenders Act vis-a-vis CRPC. Now again comes the Latin word, probo, which means I am proving my worth. ये क्या है? तो मेरे पास तो अच्छा मेरा कॉपी वापस करो. Okay. Say, as I have been telling, we are over enamored with the word which is in the Latin maxims. So here comes the word probo. Whether I have proved my worth. And we have to see whether he can live in a free society or not. And as I have been giving you the example of the 10-year-old boy stealing a loaf of bread so that his cancerous mother can eat the food, will you send him to the juvenile home or you would like to rehabilitate him? That is where the Probation of Offenders Act comes. And that is what I and Justice Pathak have been doing. Try to rehabilitate them, get them into community service so that they are helpful even in the society. When these acts were done out of certain compulsion to the circumstances which occurred at that time. And that is why this Probation of Offenders Act. He is an offender. Yes, you are not giving him the benefit if he is a proclaimed offender. Not when the offence is proved to be brutal. You don't give him that probation. Why? You have all the worry he is going to commit the same heinous crime again and again. He is not going to reform himself. See, though many constitutional wizards say that we should go away with our old sermons, either in the Bible, in the Hebrew or in the Hindu philosophies, or the what is known as your Quran. But see the genesis, the old genesis of the sentencing policy. And I gave you one clear example of how a deterrent effect would be deleterious to the society. In that simple example, you are ruining the victim's career. Forget about, yes, at the end of the day, she will see her husband behind bars. Fine. Her body anatomy is answered. But what about her mental status? What about her children? And when we say that the punishment must be commensurate with the offence committed, did he mean any offence in that example? Did she mean any offensive thing that both of them are litigating now before you? And is it not possible that if a sane police officer or a sane lawyer or a sane judge tries to reconcile between the two, which is better? Getting him behind bars for the anatomy of your body, or having perpetual happiness of your anatomy in your married life? You have to visualize these two aspects when you are sentencing a person. At times we don't know. So as I told you, we just asked the lawyer before 5 days, भैया बताना जब उसकी फैमिली में कौन कौन है? चलो बीवी मर गई, अब क्या है? Just 3 children. Okay, who looks after them? So he looks after them. How does he look after them? So जेल से जो पैसा मिलता है वो बच्चों के पीछे देता है. So this was in one fury that things happened, you know. The man is in jail since 15 years. Can you say it's a heinous crime? And where the theory of life till the last breath will apply? When you are giving Vikas Yadav 30 years in a heinous crime. So recently in Lakhanpal, you can take it, it's at page 6. So if you exercise your powers under section 360, you need not get a report from the probation officer that he is doing well. The example which I gave you, COVID, the poor fellow was being called by the doctors. He was doing his community service. At that time, do you need a probationer's report, probation officer's report? The answer is no. You give him the benefit. He is now rehabilitated. I may or may not agree with this judgment of Sanjay Dutt, but it's a judgment. You have to give him probation. They have given it of good conduct. Now, as I told you, you don't give the benefit of probation of Offenders Act to a life convict. AIR 1983 SC 359. And then now can you give, say there is only 3 years of punishment, but at the same time, can you give probation of offender, benefit of probation of Offenders Act to a smuggler? कि नहीं करेगा भैया स्मगलिंग. The Supreme Court says no. Sorry, we don't want to rehabilitate him. Sorry, don't give him that. State of Maharashtra versus Natwarlal, 1980 SC 593. So as I told you, probation of Offenders Act came later on. You had section 360 much before that. Because it was akin in 1888 Act also, the earlier CRPC. We have borrowed it in the 1973 Act. So it was there, 360 vis-a-vis it. And there is a very nice anecdote which says, and I'll end it with this because our director has said that I should not bore you more than one. Why was the dead man happy to be sentenced during his trial? Why was, इस शुरू में कहा ऐसा ही थोड़ा ताज्जुब होगा. Why was the dead man happy to be sentenced during his trial? Just answer. Just, it's a simple question. Nothing to do more with your logics or. Why was the dead man happy to be sentenced during his trial?
Because he was alive.
वो आपने पढ़ लिया, अब पढ़ के जवाब देते हो, ये ठीक नहीं करते हो आप.
नहीं, but when you said happy, no.
नहीं, ये आपने पढ़ लिया.
No,
ये
not.
तीसरी बार किया आपने.
No, sir. I'm really sorry, but not because I read it. Because you said happy, so I thought that alive. Not because I read
You
it.
see, he had already died. Understand one thing. And all the lawyers for bringing him to life and sentencing him. It's like in one of the anecdotes, it is said that the lawyer comes out running to his client and says, I've saved you from death sentence. I've been successful in persuading the jury not to acquit you but to give you life sentence. It's like that. Thank you for your patient hearing. And this 3/4, I'll just उठा के लेके आया हूँ तो कह दूँ. This is what the recent judgment of the Supreme Court is, January 2023, Munnalal versus State of Uttar Pradesh. Based on defective investigations, and a recent judgment of Justice Lalit, as he then was, suo motu writ petition. It's in 2022, Live Law Supreme Court 777. These are the guidelines for death sentencing. Suo motu writ petition. Beginning from Bachchan Singh, they've gone right up to today on death sentencing. And then you can go to, if you want my article on this, discussion on parameters which may be adopted by courts while sentencing a convict for crimes committed under narcotic, drug and psychotropic substances. Sir, you can have this and this. If they want, you can Xerox it and give it to them. And you need not give me back. Death sentence, reduction in sentence, double murder, State of Haryana versus Anand Kido. You can pass on this also if you want. Or you can keep it for your academy. And this is where I told you the learned judge had posed about 18 pages on order of sentence. What for? But thank you. Have a nice lunch.